Well, good morning, everyone. It is now 10:16 and our session's supposed to start at 10:15. When he talked about the comma, I said my AP English teacher would be mad about that Oxford comma, and I hate that comma too. That's like Judge EA, both of us say, nope, I'm not using it. But I guess we've been overruled, huh? Yeah. Right. Well, my name is Anita Laster Mays, and I am a judge at the Ohio 8th District Court of Appeals. And it is my honor to introduce these two gentlemen for this next session on be careful when moving to dismiss an analysis of Civil Rule 12. But first, I want to give credit to Judge Celebrez's Judicial Attorney Candace for putting this panel together. So we have two dynamic speakers, um, Marcel Duhamel and Matthew Fazikis, both of Vari's. Marcel is a partner in the Cleveland office, and he is also a litigator and private lawyer. His practice includes privacy, class actions, consumer protection, banking litigation, complex litigation, bankruptcy, and appellate practice. And he often lend his expertise to the legal community just to assist us and just educate the legal community. Matthew Fazikis is an associate attorney in the office, and his practice includes he's part of the litigation group, and his practice includes commercial, oil and gas, energy, workers' comp, bankruptcy, and creditors' rights disputes. And so we are happy today that they have come to share their talents with us. And thank you, and the floor is yours.
Thank you very much. Good morning. Thanks for the opportunity to speak to you. And the first question I want to answer is why? Why are we talking at an appellate seminar about Civil Rule 12, which obviously doesn't apply to appellate proceedings, right? Well, the reason is because, in my view, any successful trip to the Court of Appeals starts in the Court of Common Pleas. And if you screw up on Rule 12 in the Court of Common Pleas, then regardless of what the merits may or may not have been of your argument below, you're going to run into trouble when you get to the Court of Appeals, because the Court of Appeals is very likely to apply these rules technically as they are written, which is appropriate. So it's important to understand how these rules actually work. And there are a few traps for the unwary as well, because despite the fact that the Ohio Civil Rule and the Federal Civil Rule are nearly verbatim in almost all respects, in a few key areas, the Ohio courts interpret these rules quite differently than federal courts, and we'll talk about that a little bit. So the way we're going to divide this up, I'm going to talk about dispositive motions into Rules 12b1 through 7. And Matt is going to talk about non-dispositive motions under Rules 12e and 12f, although calling 12f a non-dispositive motion or 12e a non-dispositive motion can be a little misleading, and also the mechanics of filing Rule 12 motions below. All right, so first let's talk about subject matter jurisdiction. Subject matter jurisdiction is the subject of a Rule 12b1 motion. The standard is whether or not any cause of action is cognizable by the forum that's been raised in the complaint. What subject matter jurisdiction is not, two things. The first one is arbitration, right? So we will occasionally see a defendant move to dismiss a complaint on the theory that there is no jurisdiction in the Court of Common Pleas because there is an arbitration provision in the party's contract. Generally speaking, 12b1 is not an appropriate method to try to compel arbitration in the Court of Common Pleas. The Pappas case from the 8th District is a good example of this. In that case, the defendant moved to dismiss, argued that, gee, there's an arbitration provision, the parties agreed to arbitrate, therefore the court lacked subject matter jurisdiction. Not so, said the 8th District. The court had jurisdiction. Instead, what the court should have done was stay the litigation pending an arbitration, and that's typically the correct way to do it. You bring a motion to stay the litigation pending an arbitration, and then either the plaintiff or the defendant in that case goes out and demands arbitration of the issues that have been raised in the complaint. There could be a different outcome, perhaps, depending on how the arbitration provision is actually written. Because one thing that the 8th District did talk about in the Pappas decision was the precise language of the arbitration provision, which did not actually expressly say that the parties agreed that exclusive jurisdiction for any dispute would lie in an arbitrable forum. So query what would have happened had that arbitration provision been written that way. So that what it had said, instead of the parties agree to arbitrate, it had said something along the lines of, further, the parties agree that the Court of Common Pleas will have no jurisdiction and the only jurisdiction is in an arbitrable forum. Would that have then supported a 12b1 motion to dismiss the lack of jurisdiction? I'm not sure. But that question wasn't resolved by Pappas because it wasn't presented in that case. And I haven't seen it presented. I have, however, seen arbitration provisions drafted that way. I've drafted some arbitration provisions that way. So how that's going to be interpreted by a court remains to be seen. And this is an important area where there's a huge difference between federal practice and state practice. In federal court, a standing question goes to subject matter jurisdiction. So 12b1 motions in federal court are the appropriate way to raise the plaintiff's lack of standing to bring a complaint. Not so in Ohio. As the 5th District put it, there is a clear distinction between the requirements of subject matter jurisdiction and standing. And standing in an Ohio court cannot be raised on a 12b1 motion. It can, however, be raised on a 12b6 motion. We'll talk about that a little bit. It matters because there's a question about whether or not you can consider matters extrinsic to the complaint, right? In a 12b1 motion, often you can consider matters extrinsic to the complaint. So you can raise issues outside the four corners of the complaint in arguing that the plaintiff lacks standing. In 12b6, that's more constrained, right? Generally speaking, with some exceptions, you're confined to what actually appears in the complaint. So to argue that the plaintiff lacks standing on a 12b6 motion, as opposed to a Rule 56 motion, you have to argue that either on the face of the complaint, it's clear the plaintiff lacks standing, or alternatively, you've got some other material that the court can consider on 12b6 outside the four corners of the complaint. That's rare in Ohio, but there are circumstances where that can happen. There's also a distinction in, well, let's talk about it in the 12b2 context, personal jurisdiction. Personal jurisdiction is the subject of 12b2, not 12b6, right? So if you want to move for lack of personal jurisdiction, you have to do it under Rule 12b2. As a reminder, right, the court has personal jurisdiction if two things are true. The defendant's or the defendant's conduct falls within Ohio's long-arm statute, and conferring the jurisdiction would comport with due process of law. Generally speaking, though, if the defendant is found within the state, you're going to have personal jurisdiction over that defendant in a court of common pleas really anywhere in Ohio. Venue is a different topic. We'll talk about venue in a moment. (12B2) is resolved at the Court of Appeals de novo, not abuse of discretion. And here too, there is a difference between federal practice and state practice. In federal practice, there are two types of challenges to personal jurisdiction: facial or factual. A facial challenge turns entirely on the allegations of the complaint. A factual challenge turns on information that is extrinsic to the complaint. And in a factual challenge, the court can consider areas outside of the complaint. In Ohio, that distinction exists, but it's a little bit different, and it really turns on the conduct of the trial court. Rule in Ohio is simply this: if the Court of Common Pleas conducts a hearing, then anything that is properly admitted at the hearing can be considered by the court in ruling on the motion to dismiss for lack of personal jurisdiction, and the plaintiff bears the burden of proving jurisdiction. On the other hand, if the Court of Common Pleas does not conduct a hearing, then the court's inquiry is limited to what appears on the face of the complaint. So if you want to raise on 12B2 issues that are not in the face of the complaint, it's going to be very important that you ask the trial court to conduct a hearing. Because if you don't, and the court considers that information anyway, there is a risk that the Court of Appeals will reverse simply because the court considered information that was extrinsic to the complaint. (12B3) is fun. This is improper venue. Venue motions in Ohio are again different than venue motions in federal court for this reason. There is no such thing as forum nonconvenience in Ohio. There is, however, forum nonconvenience in federal court. What does that mean? In Ohio, the question really is binary, with one exception. There is either proper venue or there is not proper venue. And if there is proper venue, then whether it is convenient to the parties or not is beside the point. Venue is proper, so the lawsuit can proceed in that jurisdiction, in front of that court. In federal court, even where venue is proper, there are times where a court will transfer to a more convenient forum on the theory, gee, most of the witnesses are in that venue, for example. Here it doesn't matter. If the defendant is located in Cuyahoga County, you're going to have proper venue in Cuyahoga County, notwithstanding the fact that all of the defendant's employees might be in Hamilton County, right? But if you can find the defendant here, you can bring them here. What that might mean is there could be multiple counties that have proper venue over the same case. So too bad, right? If it's inconvenient for you to litigate in that particular forum, it doesn't really matter if there is proper venue. What's interesting about this, however, to me, is that the standard of review on 12B3 is abuse of discretion as opposed to de novo. And I'm not sure why. I tried to figure that out in advance of this seminar, right? I can find the source of this ruling, but I can't tell you what the policy is that suggests that whether venue is proper is discretionary as opposed to de novo review. But what I can tell you is that the law in Ohio is overwhelmingly clear that this is reviewed on an abuse of discretion standard and not a de novo review standard. We don't very often see 12B4 motions, but they do exist, and they are distinct from 12B5. 12B4 goes to the sufficiency of process, and sufficiency of process is all about what is actually in the summons, right? So do you have a summons that properly checks the boxes and then attaches the complaint? If the answer is yes, you have sufficient process. which is distinct from sufficient service of process, which we'll talk about in a second. That's under Rule 12b-5. But here too, under Rule 12b-4, for reasons I'm not entirely sure of, this is reviewed on abuse of discretion. It is not reviewed de novo. Why? I don't know. But ultimately, it is in the trial court's discretion to decide whether or not service was sufficient. If the court is going to dismiss for insufficient service of process, or insufficient process, I should say, that dismissal should be without prejudice. If the court were to dismiss with prejudice, it is likely that that would be reversed on appeal. Insufficiency of service of process is a little more common than insufficiency of process. This is really when the plaintiff fails to serve the defendant with the summons within a year of filing the complaint. Or when what the plaintiff says constitutes service, the defendant argues was not really service. Here too, this is reviewed for abuse of discretion, not de novo. And here too, I can't tell you why. I don't know why, what the policy is that supports a de novo, or I'm sorry, an abuse of discretion review here, as opposed to a de novo review. But I can tell you that that appears to be the law. There are service by publication rules, but it is really important if you're going to attempt to serve by publication, you check the boxes. Because there are good reasons for service of by publication to be disfavored, right? There's a really good chance that the defendant didn't actually know that they were being sued when you serve by publication. So if you are going to serve by publication, you must file an affidavit that states all of the efforts you made to determine where the defendant could be found and the efforts you made to serve the defendant at that location. And if you fail to do that, your service of publication will likely be deemed to be insufficient service. That's what happened in the Lewis v. Butson case. Because the plaintiff there had not actually filed an affidavit that specifically established all of their efforts in enough detail, the Court of Appeals concluded that the affidavit was insufficient and service of publication didn't work. So I'm a civil litigator, right? So Rule 12b-6 is one of my favorite rules. It's an interesting rule. Failure to state a claim upon which relief can be granted. There is a lot of paper, a lot of ink has been spilled on what is the distinction between notice pleading on the one hand and pleading sufficient facts to state a claim on the other. And here too, there is a difference between federal practice and state practice. We'll talk about that in a moment, but I also want to mention Rule 12c. Rule 12c is theoretically identical to Rule 12b-6 with this exception. Rule 12c can be filed after you answer, and Rule 12b-6 is filed before you answer. They are otherwise identical rules. You file a Rule 12c motion because you want to argue that the complaint fails to state a claim on which relief can be granted. Only difference between 12b-6 and 12c is when it is filed. 12c is filed after the answer. 12b-6 is filed in lieu of an answer. If that's true, query, why would you ever file a 12c as opposed to a 12b-6 or a 12b-6 as opposed to a 12c? Two answers. There are times where it may make sense to answer the complaint and then file a Rule 12c. There are times where I've done it. And in particular, one weird anomaly that can result in 12b-6 practice. If the Court of Common Pleas allows that motion to linger for a very long time. And if the Court of Common Pleas does not stay discovery or the rest of the proceedings while it's considering a Rule 12b-6, you could, in theory, find yourself in the situation of a year after filing your motion to dismiss, after having taken and defended a half dozen depositions, after having fully briefed a motion for summary judgment, and while attending the final pretrial on a Friday afternoon with trial scheduled on Monday, the Court of Common Pleas announces, I am denying the motion to dismiss. Well, the defendant has never answered. And if the defendant has never answered, the defendant has also never had to file a counterclaim, because under Rule 13, right, your counterclaim is due when the answer is due. So in theory, you could now have, on the morning of trial, a counterclaim filed for the first time. The other problem with that could militate towards filing a Rule 12c if you are concerned that could happen to you, and you want to make sure that your counterclaim is is brought in a way that the Court of Common Pleas is going to pay attention to, right? So if I'm likely to have a counterclaim, I'm more likely to file a Rule 12c than I am a 12b-6. The other potential trap, you file a 12b-6, my parade of horribles plays out, and frankly, yeah, you didn't answer, right? You've been litigating this case for a year, and you just forget that you didn't answer. And then you want to raise some argument that constitutes an affirmative defense, and you never pled the affirmative defense because you didn't answer. You're out of luck. So there are times where it makes sense to answer and file a 12c. Having said all of that, my personal experience is that district courts in federal court are a little more familiar with Rule 12c than the common pleas judges are in Ohio court. So sometimes when you file a Rule 12c motion in an Ohio court, you have to take the time to explain to the common pleas judge that it really is identical to a 12b-6 motion. It's just a question of timing. Twelve B6 and 12C are both reviewed de novo. In Ohio, prevailing on a 12b-6 motion, if you are the moving party, is arguably a little bit harder than it is in federal court. Why? Well, two U.S. Supreme Court decisions called Appellate Advocacy established a standard that requires not only a short, plain, concise statement of the claim, but also that the plaintiff pleads sufficient facts that give rise to a plausible claim for relief. That plausibility standard is different than the standard that had been articulated by the U.S. Supreme Court case in a case called Conley v. Gibson, which is still the standard in Ohio. Right. So in Ohio, the question is there any facts? Are there any facts consistent with the complaint that could give rise to liability? If the answer is yes, then the complaint states a claim. So federal court's a little bit more likely to grant a 12b-6 motion than a state court. Does not follow, however, that you cannot get a 12b-6 motion granted in Ohio, because short, plain statement does not mean conclusory allegations, right? It's not enough to say, defendant tortiously interfered with my contract, I win, right? You still have to plead sufficient operative facts so that if those facts were true, the plaintiff would prevail. What the plaintiff in Ohio does not have to do is plead with any specificity those facts. So they have to plead operative facts, but they don't have to prove their case in the pleadings. I should point out the 8th District has been very clear, by the way, in Toledo. The court has not adopted Iqbal and Twombly. Those cases have been cited by appellate courts, and in a few cases they've even been cited for the for the proposition that the plaintiff needs to plead plausibly. But for the most part, Ohio courts have been pretty clear that the Iqbal and Twombly so-called heightened pleading standard, if that's what it is, has not been adopted in Ohio. Standing in Ohio can be brought under 12b6, not under 12b1. This gets interesting because often standing is going to require some information outside the context of the complaint, right? It's not going to be that often that a plaintiff's complaint fails on its face to assert proper standing because you don't have to allege standing, right? So often you're going to want to point to something outside the complaint that suggests that the plaintiff doesn't have standing. Well, that gets interesting. Generally, right, a court can't consider anything outside the scope of the complaint or its attachments on a 12b6 motion. But first, it is clear if the plaintiff attaches anything to the complaint, the court can consider that. But in addition to that, the court can take judicial notice. And I want to talk about judicial notice on 12b6 motions here too, because I think there's a little bit of an unsettled area here because there is some tension between the decision of the Ohio Supreme Court and subsequent decisions of Ohio appellate courts on this topic. And I don't know how that tension is ultimately going to get resolved. Right. So generally speaking, a court can take judicial notice of facts generally known in the jurisdiction, capable of accurate or ready determination by resort to sources that cannot reasonably be questioned when ruling on a 12b6 or 12c motion. Interestingly, though, the 8th District has said that a court may not take judicial notice of prior proceedings before the court, even if the same parties and issues are involved, right? Which is another way of saying the court can't take judicial notice on a 12b6 motion that raises, for example, res judicata. Very different in federal court. In federal court, res judicata is always resolved on 12b6. You would never have summary judgment on res judicata. That would go to 12b6. In Ohio, there is some clarity, or a bit of a lack of clarity, because there is a case called Everhart v. McIntosh, State XRL Everhart v. McIntosh. It's not on the slide, but if anyone's really interested, it's at 115 Ohio State 3rd, 195, in which the court said, the Supreme Court said, courts can take judicial notice of public court records available on the internet, which implies that on a 12b6 motion raising res judicata, for example, if the prior proceeding appears on the public docket of a court, on the public website, then on 12b6, the court can take judicial notice of it. The appellate courts in Ohio have been less than entirely consistent on this topic. Some courts have said, we will consider that on a 12b6 motion in the res judicata context or in the standing context. And other Ohio appellate courts have said, nope, it's not attached to the complaint, and therefore it's improper on 12b6. I don't know how that's going to play out at the end of the day. 12b7, failure to join a party under Civil Rule 19 or 19.1. This is an often abused rule by litigants on both sides of the V. Rule 19 requires that a party has to be joined when any of the following is true, right? The party's absence will preclude complete relief from being given. The party claims an interest in the action and is so situated that disposition of the case without it would be impractical. Or she has an interest as an assignor or assignee or subrogor or subrogate. A ruling on 12b7 by the Court of Common Pleas is reviewed by the appellate court de novo. But generally, despite being a motion to dismiss under Rule 12b7, courts don't actually dismiss the case. What typically a Court of Common Pleas is supposed to do is direct the plaintiff to join the necessary party and then dismiss the case if and only if the plaintiff then fails to do that. Or if it is simply impossible to join the necessary party. If you can persuade the Court of Common Pleas that joinder is necessary, and it is simply not possible for the plaintiff to accomplish that, then a 12b7 motion can result in a dismissal. That'll turn it to my colleague.
Thanks, Marcel. And before I jump in, I want to give two shout outs. First, to Candace Waba for coming up with the pun title for our presentation, as well as thank the court for giving us the opportunity to speak with you all today. And actually, a third shout out to Drew Fleming. He's an associate in our office. He helped put this PowerPoint together and do the research for us. So if he's watching online, thanks, Drew.
No, it's embarrassing.
That's why you have associates, Marcel. So we're going to start with Civil Rule 12E. As Marcel mentioned, calling Rule 12E and then Rule 12F as a non-dispositive motion can be misleading, but it generally isn't. So under Rule 12E, you can move the court for a more definite statement when the pleading is so vague or ambiguous that a party cannot reasonably be required to frame a responsive pleading. Well, what does that mean? That's a great question. There's not a ton of case law interpreting when a pleading is so vague or ambiguous that a party can't respond to it. Its most common application is in conjunction with Rule 10. And under Rule 10, there's two situations when there's certain attachments you have to include with a complaint. The first is when your claim is based upon a written instrument, you need to attach that written instrument to your complaint. So if it's a breach of contract action based on a written contract, you need to attach that contract. The second application is in malpractice cases, you need to include what's called an affidavit of merit with your complaint. The failure to attach a document in compliance with Rule 10 is not grounds for dismissal under Rule 12b6. Courts have been unanimous in holding that Rule 12e is the proper remedy for a defendant based upon a plaintiff's failure to comply with Rule 10. So if you get a complaint that doesn't comply with Rule 10, you file Rule 12e, the trial court should grant that motion and order that the plaintiff file a new complaint or an amended complaint with the attachment. If the plaintiff then fails to do so, then the trial court can then dismiss the case. But if you decide to move for 12b6 based on failure to comply with Rule 10, you're going to get reversed on appeal, so you're going to want to avoid that. Next, Rule 12f. Rule 12f is your motion to strike. And under Rule 12f, a party may move the court for an order to strike any insufficient claim or defense or any redundant, immaterial, impertinent, or scandalous matter. Like Rule 12e, there's not a ton of case law providing guidance on what those words mean. There is case law that suggests Rule 12f is limited to pleadings. We as litigators tend to refer to pleadings broadly as anything filed in court. We might have our file that has a pleading section or a pleading split, but Rule 12f is limited to pleadings as defined in Rule 7, so that's your complaint, an answer, a reply to a counterclaim, a counterclaim, a cross-claim. So don't use Rule 12f to strike something that isn't one of those things. There's probably a case or another rule that could give you a basis to strike something else set with the court. For example, Rule 56 would allow you to strike certain affidavits that don't comply with the rules. I don't want to spend a ton of time on this slide. There's sort of a really academic distinction under Rule 12 that kind of doesn't matter at the end of the day. But in the Neff versus Corden case, the Supreme Court of Ohio has suggested that Rule 12F should be used when you're moving to partially dismiss a complaint as opposed to the entire complaint. And in this case, the trial court used 12F to dismiss an entire complaint. And the Supreme Court of Ohio said that was incorrect. You should have used 12b6. But then the court said it didn't matter because it failed to state a claim anyways. Right? If you look at the prong of 12F, it's a legally insufficient claim or defense. That sounds like failure to state a claim to me. And on the flip side, if you partially move to dismiss under 12b6, maybe you should have used 12f, but there's case law within the 8th district that holds it doesn't matter. If the ruling was proper under 12b6 or 12f, who really cares? So moving now, I think, to the more interesting portion of the presentation, the more practical portion of the presentation is your mechanics for filing your Rule 12 motion. So the timing for filing a Rule 12 motion is the same as filing your answer. You have 28 days from service to file a Rule 12 motion. Now, as Marcel talked about earlier, certain motions you don't have to file before you answer, but should you choose to, you have 28 days before you answer. And there's three distinct categories of additional constraints with respect to Rule 12 motions. The first is your 12b1 motion for lack of subject matter jurisdiction. That can be raised at any time after you answer, at trial. You can even raise it for the first time on appeal. And the basis for this is pretty simple. If a trial court lacks subject matter jurisdiction over the action, it can't enter judgment in the action. You can't, courts have held that parties can't consent to subject matter jurisdiction or waive subject matter jurisdiction. The court either has jurisdiction or it doesn't. The second category is 12b2 through 5, that's personal jurisdiction, venue, and the two service rules. And in this situation, we'll talk about it on the next slide, you either waive it by failing to move to join it in a Rule 12b motion, or you don't include it in an answer if a 12b motion had not been filed. And the third category is 12b6 and 12b7. Similar to 12b1, you could file this really at any time because Rule 12c gives you the opportunity to file a motion for judgment on the pleadings. And the rule is explicit, you can raise these defenses in a Rule 7a pleading, your motion for judgment on the pleadings, or even at the trial on the merits. And as I was thinking about this, well, why would you wait until the trial of the merits to move to dismiss? Would you want to do that earlier, save your client some time and money? And what I thought of one example could be, there's a statutory claim in the complaint, and the day before trial, the Ohio Supreme Court says that statute is unconstitutional. Then you have the opportunity at trial to say, Your Honor, this case no longer states a claim based on this new case. So under that second category of motions, as I mentioned, you will waive them if you don't join them with a Rule 12b motion, or if you fail to include it in your answer. So by way of illustration, if you move for a 12b2 motion, and the court denies that, you can't then move for 12b. If you have a defense under 12b2 and 12b4, you need to join them at the same time. And if you move for a 12b motion, you can't then later raise any of these motions because you put it in your answer. Conversely, if you don't move under Rule 12b and you preserve these defenses in your answer, you could raise these at any time, and I'm getting the 5-minute time, so I'm going to skip ahead. Because that's the most interesting part of our presentation. 12b6, again, you don't really waive it. I kind of explained this because you always have the opportunity for 12c or raising it at the trial of the merits. Okay, so the Ohio Supreme Court's addressed the issue of, well, does active participation in a lawsuit waive your right to raise a 12b5 defense for insufficiency of service of process? And what the court has done in 2 decisions has held that active participation does not waive this defense so long as you comply with Rule 12h. And that's, as I discussed, the raising it in your answer or including it in a Rule 12b motion. So in 2007, the Ohio Supreme Court in Glioso versus University Urologists of Cleveland, Inc. addressed this very question. And in this case, the plaintiff attempted service by certified mail. The certified mail failed, but the defendant nonetheless had notice of the proceeding, appeared, and litigated the case for over a year. The defendant did not file a Rule 12b motion, but instead included that defense of insufficiency of service of process in its answer. Despite participating in the case for over a year, conducting discovery and filing a dispositive motion before trial, the trial court determined that because there was no service, it could dismiss the action. The plaintiff in turn said, wait, hold on. Service, the whole point of service is to provide notice to the defendant and give them an opportunity to appear and defend the case. That was achieved here, even though technical service had not applied. The 8th District agreed with the plaintiff and reversed the trial court's decision, but the Ohio Supreme Court agreed with the trial court for the simple reason that the rules are explicit in how you preserve these defenses, and the defendant followed it. And the quote from the case is, whether or not the defendant's strategy constituted gamesmanship or good litigation strategy, they followed the rules. So in the aftermath of Glioso, Ohio Courts of Appeals begrudgingly applied Glioso as being unfair. And it is to an extent, right? You appeared, you came into the action. What's the harm of, you didn't actually sign the green card with the complaint? And this is in contrast to the federal standard. Under federal law, at least within the Sixth Circuit, active participation that would suggest that you're going to defend the case on the merits waives your right to assert personal jurisdiction in circuits. This makes sense in a way. But just this year, the Supreme Court reaffirmed Gliozo in Ackman versus Mercy Health West Hospital LLC. This case is even worse than Gliozo. In this case, the defendant, it was a medical malpractice case. The plaintiff got good service on the defendant hospital, but they didn't get good service on the individual defendant. And the problematic portion of that for the plaintiff is a hospital's liability, medical malpractice is based upon vicarious liability. So if the doctor's not liable, the hospital's not liable. Because the defendant doctor was never served, the defendant properly preserved the 12b5 defense in their answer, and then the day after the statute of limitations lapsed, moved to dismiss under 12b5. And what's important is that under Rule 3, a case isn't commenced for purposes of a statute of limitations until service is effectuated. And so what happened was the trial court found, yep, there was no good service on the defendant, and therefore we're dismissing them. And we're then compelled to dismiss the hospital because its liability is premised upon the defendants. And you can't refile the case because you never commenced the case in the first place under Rule 3, so the saving statute doesn't save. On appeal, the Supreme Court said, look, Gliozo is still good law, and we're going to affirm Gliozo for the simple reason that it's predictable. Unlike the Sixth Circuit standard, we know when a defendant preserves or does not preserve a Rule 12b5 defense based on just looking at what the rule says. In contrast, the court cites to a 2021 Sixth Circuit case in which for the first time the Sixth Circuit addressed whether filing a notice of appearance constitutes a waiver of your personal jurisdiction defense. So I think the Supreme Court took the practical approach of we don't want to have to, every time there's a new situation, give an answer. Just follow the rules and you preserve your defense. And on one final point, both the majority and the concurring opinion relied on Rule 1. Rule 1 provides that cases the rules should be interpreted to affect just results and to eliminate impediments to the expeditious administration of justice. On one hand, if you're the plaintiff, you lost the case on a mere technicality. That's not a just result. But for the defendant, when a defendant follows the rules, it wouldn't be just for them to allow the plaintiff to proceed despite doing what they were supposed to do. So with that, I'm giving you a cue card to say that it's time for questions. So if anybody has any questions.
Before we do that, there's one last practice pointer, both at the Court of Appeals level and at the trial court level. Look out for amended complaints, which reset all of these preservation requirements, right? So you file a motion to dismiss, the plaintiff amends the complaint. Whatever you said in your original 12b6, it's as though it was never said, right? Now there is an amended complaint. So whatever you think you preserved with respect to that first complaint, it is no longer preserved. Once there is an amended complaint, you must assert whatever it is that you want to preserve. And if you don't, the fact that you asserted it in response to the first complaint will not help you, because an amended complaint simply takes the place of the first complaint. It's as though the first complaint was not served at all, except for relation back in the statute of limitations.
Much, Marcel and Matt. We're going to take a break until 11:15, and then we'll pick up with one final session before lunch.